Okay.
Hello, everyone, and thank you all so much for joining us on our first webinar of the month of June. Today, I am joined by our awesome managing attorney, Ruby Powers, and we are here to discuss the Asylum one-year deadline. Just some quick background information on our attorney Powers. She has been licensed since 2008 and founded her firm back in 2009. She is also a board-certified immigration and nationality attorney. Attorney Powers, do you want to go ahead and take it away?
Yes, thank you. This is a very important topic. We here at Powers Law Group have worked on asylum cases I've worked on cases for like 15 years or something like that, if not more, even in my internships and as an a law student at the immigration clinic at U of H. And, this 1 year filing deadline and its exceptions are just a really hot topic all the time. A lot of people don't know about asylum when they really need to know about it. And they sometimes they miss this deadline because of that. And so there are some exceptions. We're going to walk through what that is. And, just a little bit about, I was counting the other day, as we move to the next slide, we have represented individuals from, I think, like 30 different countries, for 34 maybe. I just for Asylum. So here at Powers Law Group, we've represented individuals from many different countries on lots of different aspects. So under IRA of 1996, they made a requirement that asylum applicants must file within 1 year of their last entry in the United States. And they must demonstrate by clear and convincing evidence that the application was filed within 1 year after the date of the applicant's arrival. IRA just never ceases to remind me of all the difficult aspects of law that they brought upon us, because they created unlawful presence. They made the waivers and the bars, the 3 to 10 years, and the permanent bar. The definition of aggravated felony, and changed what the false claim to citizenship into an actual permanent bar, if you will. So I didn't even realize the 1 year filing deadline came from IRA, but let's move on. So we have that to thank. So basically you need to file within 1 year of entry. And if you don't, there are what we call the extraordinary circumstances, and there's changed circumstances. And so you want to ideally meet in one of those two. And honestly, if you are not in the 1 year filing deadline, then you're going to really need to explain why you missed it and put yourself in one of these other exceptions, or else the asylum office they're just going to refer you to immigration court, or they could say you're not eligible for asylum and you're only eligible for maybe withholding or a removal or convention against torture. So let's walk through some of these exceptions. So and right before we do that, let's just give an example what the 1 year filing deadline is. So let's say you came in on January 1st, 2022. That means you need to be receipted by January 2nd, 2023, because they don't count the day you flew in as actually you don't lose the whole date. Now, do you want to be remembering this and be counting down to the last second? No, you never want to do that. You want to file this as soon as you can, as soon as you realize you're eligible and you qualify. You want to submit it as soon as you have a pretty good product to send it off. I'll tell you, yesterday we received a receipt. It took 8 weeks for the affirmative asylum, 8 weeks. So what happens is if you submit it and for some reason it gets rejected or what have you, you might not know if it met your 1 year filing deadline, because right now they're taking 8 weeks to get you a receipt notice. So let's move on to those exceptions. So the standards for extraordinary, we have to go back a slide because I was talking too much about the extraordinary circumstances exception. So to succeed in showing why you're late, that you meet one of these exceptions, you need to show one of these things: that the extraordinary circumstances took place in your life for directly related to the failure for you to file, and that your own intentional action or inaction did not cause the extraordinary circumstance. So your own intentional action or inaction did not cause it. So Basically, it was beyond your control. Let's move on to the next slide. So here are some examples. Your own health. So if medical issues prevented you from filing a timely application, you were dealing with you would need to have reports from medical professionals show that you're incompetent, disabled, or otherwise unable to apply, should be signed by a medical professional on official letterhead, and should be accompanied by copies of x-rays, medical charts, or medical notes. Right now, we actually have a client that's regularly in the hospital, and we were hoping to file, but we're going to have doctor's notes, and we're explaining that he has been in extensive care and it's preventing him from being able to file. We've also had clients battling breast cancer or were found out they were pregnant, they didn't know about it, that were traversing to the United States. And there's some more delays and health concerns. So, the more you can support your argument about the health, then the more evidence that you can, the better. The other concern could be if there was a death or serious illness in your family, someone close to you, you would want to show as much proof as possible, the copy of the death certificate, medical records. I would write even a statement onto that effect, how it impacted you directly. The other point could be if there was abuse or crime issues that kept you. If you're a victim of a crime, you were detained, by an abusive relationship, restricted your freedom to be able to apply, that kept you from being able to move forward. So you'd want to give as much detail as you can, because a lot of this there's case law, but it's also very discretionary. And so you want to make it as compelling as possible. So on to the other reasons on the next slide, include the incompetence of a notary or attorney. So maybe you hired someone and you have proof that you hired them and then they were working with you, and then, I don't know, maybe they just disappeared, they had health issues, they had concerns, they weren't able to help you, they withdrew. You need to be able to explain what happened, and what they promised you. You have a contract, you can show that you did try to apply early when you did. And then the other concern would be if USCIS rejected or returned the I-589. So that was really, really popular. If you do not put NA or non-applicable to lots of fields, they would reject it. It was very popular during the Trump era, maybe even before that. Can't remember right now, but it was so popular that I pretty much would not want to file anything last minute, because on the one off chance we didn't put in it could get rejected and then we'd have to send it back in again. So the agency rejects a lot of different applications for minor reasons. They're getting better. They made a promise they're getting better, and we haven't seen it as bad. But if you can show that it was rejected and then you returned it as soon as you could, and that you refiled within a reasonable period, if you can show that evidence with the mailing receipts and copies, so that's why you want to keep copies. Please keep copies. Tracking copies, everything, of everything you possibly can. Then this could still be met as you could still meet the requirement. But for example, if you get a rejection, you want to respond like almost the same day. You don't want to sit on it very long, because everything is going to be scrutinized of whether you met this extraordinary circumstance exception. So let's move on to the next. So change circumstance exception is that you must show the change circumstance in your personal life, like maybe it could be like divorce or marriage, or you were being targeted to your specifically conditions in your home country or in the United States that's material to your application, and that you filed reasonably. A lot of times the interpretation is within 6 months of filing within that changed circumstances. So, but you've got to really explain what was going on, what play by play, why that changed, when you found out about that changed circumstance, what did that changed circumstance do to you? When were you able to react to that changed circumstance? Why did it take so long? We had a client that was, his wife filed for a divorce, and it was unexpected. And then it was real close to his 1 year filing deadline, and then he was gonna file with Asylum with her, and then the divorce, and it just got really messy all at the same time. But there was about a 3-month delay. But we were in the affirmative interview, we were able to explain the changed circumstance, and then he was able to get approved. So we were really happy for that. And we just explained it, what happened. And there was a discretion, and he had a really good reason for his delay. So let's move on to the next slide. So here's some other examples. So maybe you were not afraid to return home when you entered, but you're afraid now because people like you are being persecuted. Or there's been a change in government. I mean, there's elections all the time, and one election result can bring about a whole chain of events that could put your life in peril, in some cases, unfortunately. So a lot of times also what's happening in a country is maybe being censored, and you don't know what's happening until you're about to go back, and then somehow you find out because people are keeping it from you. Or I mean, there's a lot of censorship, in the journalism, as well as what the governments are trying to get that information from being out there. So anyway, it sort of depends on what your circumstances are. But if you can explain what you found out, what happened, how it impacts you. So it also could be changed circumstances, like you started becoming involved in political or religious activities after leaving your home country. Like maybe you became more involved here in the United States, and you're posting about it and you're active about it. You feel more emboldened to do it here, but then you're like, oh no, my visa is about to expire. I have to go back home, and this activity will not be condoned in my home country. And this is who I am, and it's a protected ground, and I don't have to hide who I am for going back to my home country. So asylum law could also change, and we've seen that also, where maybe you weren't eligible before, and maybe there's a newer interpretation. We see this a lot with particular social group interpretations. We've seen it was harsher under the Trump administration, and there's a bit of a reversal under the Biden administration. But and I mean, that's really hard for one to know without having a consultation and talking to an experienced immigration attorney who knows asylum. And then the other thing, like we briefly mentioned, is the relationship with the primary asylum applicant. The spouse or parent has ended, and now you need to apply on your own. So you can retain the same receipt date, priority date, but you want to make sure that you act quickly and you inform USCIS Asylum Office what your intentions are and why you're doing that. So let's move on to the next slide. Now, you must file within a reasonable amount of time after that change or extraordinary circumstance. So recap, you need to file within 1 year. And if you don't, you need to either be under the changed or extraordinary circumstances. And then you need to not have too much delay. So a reasonable depends on the unique combination of all the facts. The adjudicator with the asylum officer or the judge is going to try to look at the whole situation. And in addition to the facts, the cause of delay, other relevant factors. So any delay when you first became aware of changed circumstance, that's why it's really important. When did you find out about this? What did you do next? How long did you sit on that information, or did you act quickly? Your education, background, and language skills, how long it takes to obtain legal help. Unfortunately, a lot of times, I find that there's not everyone is very familiar and experienced with asylum law. And of those who do, they either are residing in like the nonprofit world, which are often inundated with work and limited based off of grant funding. And then in the private sector, we like here at our firm, we have experience in this space, but sometimes the cost may be a bit out of reach for some individuals. That's why we do have payment plans and things. But anyway, so that's why when you ask for obtain legal help, sometimes people have delayed because they were waiting for a nonprofit, but the nonprofit had a long queue in line. And so that really isn't, you can put that into factor, but I wouldn't depend on that as being the only reason that you would be authorized for not meeting the 1 year filing deadline. The other thing to consider is physical or emotional effects of persecution. And, there could be something going on with your trauma being difficult for you to express what happened. And I think that would be best used with a psychiatric medical report that helps explain your what's causing your delay. So you want to apply within as soon as possible. I often see the magic number is around within 6 months, but the less you can be under 6 months, the better. So let's move on to our next slide.
Yes. So thank you all so much for joining us today. And if you guys like these webinars and want to stay connected with us, we do go live every Wednesday at 11 a.m. Central, and we discuss a variety of topics depending on what's going on. If you guys want to stay connected with us on social media, we are on Facebook, Twitter, Instagram, TikTok. We also have a newsletter that goes out bi-weekly. You guys can find that information on our website. And then next week, we will be discussing what is the I-751. So if you guys are interested in that, go ahead and join us live next week. But thank you all so much for joining us today, and we hope to see you next week.